Today, we're going to law school. And I told you to brace yourselves. You've got two superb professors here from our law school. I'll turn it over to Todd, who can tell you whether or not it's constitutional to begin with.
Yeah, I can tell you the answer is no. Well, this is actually going to go a little differently than most law school courses, because most law school courses, we talk about a topic, the Appointments Clause of the Constitution, the president's removal power, and then we spin off a lot of different factual hypotheticals. Today, we're doing the opposite. We're starting with a particular factual hypothetical, the Federal Open Market Committee in particular, to some extent the governors of the Federal Reserve Board, and we're going to spin off a whole bunch of constitutional theories about why it might be unconstitutional. And there are actually a bunch. And so to start, what we really need to do is understand a little bit about the Open Market Committee. As you know from Chairman Bernanke's presentation, the Open Market Committee, as he said, monetary policy is conducted by the FOMC. The Federal Open Market Committee makes monetary policy for the United States. 5 members are presidents of the 12 regional Federal Reserve banks, including always the president of the New York Federal Reserve Bank, specified by statute. And the presidents are elected by the boards of directors of the Federal Reserve banks, which are substantially private. Art, you know this better than I do. Can you explain the rather Byzantine process for electing FOMC?
Right. So the boards of the Federal Reserve banks are 3 classes. Class A directors are elected by the banks who are members of the Federal Reserve in that district. There are 12 different geographical districts which were set up in 1913 because the Federal Reserve was a compromise between those who wanted no central bank at all and those who wanted a very powerful central bank focused primarily around the New York money market. And so those who said, we can have a central bank, but it can't be focused, said we want a geographically spread bank with these regional banks around the country. So they will reflect the views and interests of the regional bankers and the regional economies in these various parts of the country. So there are 12 regional Federal Reserve banks. Each of them have 9 directors in 3 classes. So the Class A directors are elected by the member banks themselves, and they're bankers. They are actual bankers chosen from among the various banks. Class B directors are not bankers. They can't be actually employed by a bank, although they can own stock in a bank. But they are elected by the bankers. So not surprisingly, the Class B folks tend to be maybe people who were previously bankers but not now, or often corporate CEOs of major companies that do a lot of business with banks, non-financial companies who are major clients of banks. So the banks elect the A and the B directors, and the C directors are so-called public interest directors, but they're actually recruited and nominated by the regional Federal Reserve banks. They then go to the Federal Reserve Board in Washington. Federal Reserve Board in Washington will approve the recommendations. Normally they get about 2 or 3 recommendations for each slot. Federal Reserve Board will approve one of those. So the Class C directors are appointed by the Federal Reserve based on recommendations made by the regional banks, and then one of those Class C directors is selected by the Federal Reserve Board as chairman, but the really powerful person is the president. It used to be that the president was elected by all the directors of each bank, which meant the banks could control it, since they elected 2/3 of the directors. After the financial crisis, due to some real scandals, or at least appearances of scandals that we'll talk about, the Dodd-Frank Act took away the voting power of the Class A directors for Federal Reserve Bank president. So only the B and C directors now vote together to designate the president of the Federal Reserve Bank. So that's where the Federal Reserve Bank presidents come from.
You can see why, as a constitutional scholar, I didn't want to describe that Byzantine process. So the significant point from our perspective is that even with the changed procedure, the heads of the Federal Reserve banks are essentially privately appointed, okay? And there are a number of consequences that flow from that. And the consequences from a constitutional perspective fall in 3 categories. Number 1, it could be that the delegation of authority to the Federal Open Market Committee, containing 5 essentially private members, is an improper delegation of legislative authority by Congress. There's a series of cases on this that I'll talk about briefly. Second, it could be that the appointment procedure is inconsistent with Article 2, Section 2, Clause 2 of the Constitution, which is called the Appointments Clause, which requires that appointments generally be made for principal officers, which I actually think these people are, by the President with the advice and consent of the Senate, and even for inferior officers by the President or the heads of departments or the courts of law. And that's a much more specific provision in the Constitution that poses a real problem for the FOMC. And finally, there's a removal problem because the FOMC members, the 5 Federal Reserve Bank members, there's no provision that allows for removal of them from the FOMC. There is a provision that allows the Federal Reserve Board governors to remove them for cause as presidents of the Federal Reserve banks. But that's sort of a double insulation, and as we'll see, that poses some problems under the Supreme Court's removal jurisprudence. The big issue that this presents, the big question we want to think about here is accountability versus independence. That is the crucial issue here. How much do we want the people running our government to be accountable? And when is it important for them to be independent? And when is it constitutionally permissible for them to be independent? This was a huge issue for the framers, who generally believed in accountability and checks and balances. And even with respect to the federal judiciary, where they had a real reason to want federal judges to be independent, because colonial judges were not independent. English judges were. Ever since the Settlement Act of 1701, they could only be removed and were allowed to serve during good behavior. But colonial judges could be removed by colonial governors. And one of the grievances in the Declaration of Independence was that he, meaning George III, has made judges dependent upon his will alone. So they had a big commitment to that. They put in Article 3 that judges could only be removed when they didn't comply with the good behavior standard, which they took straight from England. So there's a real strong move to have judges be independent. And even so, there was an intense debate during the ratification about the independence of federal judges, where that was the strongest argument for independence. But the anti-federalists in particular were upset because this would be unchecked power. Now, Hamilton in the Federalist 78, 77, 79 had an answer to this as to why they wouldn't be unchecked. But boy, this was a really hard debate. It was one of the things that made ratification most controversial in the state ratification conventions. So we want to really think about accountability here, particularly accountability when it comes to setting monetary policy, which is a unique setting in this particular instance. So what I want to do before we start this is to talk a little bit, as little as possible, but to give you some background in constitutional interpretation. The Constitution does not interpret itself. And there are wide differences of opinion on how the Constitution should be interpreted, okay? And for these purposes, we'll break it down into 2 schools of thought. It's an oversimplification, but it represents 2 schools of thought, particularly on the structural Constitution that we'll be talking about today. So these 2 schools of thought are called formalism and functionalism, okay? A formalist will believe that the text is easily understood, that you can read the text and know what the text means and make a rule from the text, and that's not a big interpretive problem. A functionalist is very likely to believe that the text is indeterminate and subject to a lot of different meanings, and therefore is subject to different interpretations over time. A formalist believes in what I would call static originalism, that the text create rules, and the rules are the same for all time until the Constitution is amended. A functionalist is more likely to be sort of a dynamic originalist. So although the formalists tend to call the functionalists non-originalists, they would object and they'd say, no, we're originalists. We just believe that what the Constitution does is establish broad principles that stay the same And that's our originalist view. We interpret the Constitution as the principles were originally understood by the framers, and we apply them. But because they're principles and not rules, changes over time, such as, for example, the accretion of huge amounts of authority in the executive branch, can result in changes in the rules that flow from those principles. So, for example, if the executive branch gets so big and Congress has a hard time controlling it, Congress can create a legislative veto where they can, by one house, veto an action of the president without passing a bill. That was the kind of provision that was in effect for 60 years. And there were 200 of them in different federal statutes. We'll talk about that in just a second. Formalists believe in an emphasis on separation of the branches and separation of powers. Functionalists believe in checks and balances, overlapping power. All right, so formalists would say, stay out of my business, legislature, I get to run my executive branch, okay? Functionalists would say, no, there needs to be a lot of checks and balances in order for the branches to keep each other in check, to keep each other in control so that no one branch exceeds its authority. Formalists believe in formal and permanent rules. Functionalists believe in a balancing test that's designed to preserve the power equilibrium between the branches. So a formalist would say, well, wait a minute, is this statute consistent with the way that Congress, the Constitution sets up the rules for governing the federal government? And a functionalist would say, well, we're not that picky. We have to see if it really disrupts the balance of power between the branches, or if, in fact, it actually helps to reassert the balance of power. And if it does, then we're going to be much looser with respect to the interpretation of the Constitution. Formalists tend to be very pessimistic about legislative motives. They think that Congress will screw it up if you let them screw it up. Okay? Functionalists are optimistic about it. They think, look, we got to leave it up to Congress to be able to make changes in our government, and we can trust them to do it well. Formalists tend to believe in the flexibility of the political system. So if the constitutional system is rigid, that's not a problem for them because they think the political system can accommodate it. So we strike down the legislative veto? Not a problem because Congress has lots of ways to check and control the executive branch through the appropriations power, through the confirmation of executive branch appointees. There are lots of ways that you can get around the limitations of the Constitution through the flexibility of the political system. Functionalists tend to believe that the political system needs more flexible constitutional rules. So they would say, no, we need a legislative veto because the political system is insufficiently flexible to take account of the complete shift of power between the legislative branch and the executive branch, okay? So a broad description of two different styles of constitutional interpretation, and we'll see how that plays out and how that might be relevant to the issues we'll address today. Now, as it turns out, the Supreme Court applies these principles in different ways depending on the kind of issue that they're addressing. So, if we look at the kinds of constitutional issues that, that you could encounter, so we start out with, say, the middle row, okay? And you've got this list here in the handout. And the middle row is basically what kind of actions does the Constitution permit each branch to take, assuming there are no statutes at all, no statutes. And so for the executive branch, for example, we've got an early case on that was called In re Nagel, where a Supreme Court justice was attacked and a federal marshal attacked the assailant and killed him. And then he was prosecuted for murder by the California state courts. And it went to the Supreme Court, and the issue was, well, did he have the authority to protect the president, to protect the justice of the Supreme Court? And the Supreme Court says, yes, the executive branch has inherent power, even without a statute, to defend members of the federal government, okay? Congress has inherent powers that some are expressed in the Constitution, like the power to legislate, but some are implied, like the power to subpoena documents and the power to subpoena witnesses and the power to hold witnesses in contempt if they don't come. And that flows from the legislative power because you can't legislate without that authority. Similarly, judges have the same kind of contempt power for essentially the same reasons. All right, this all exists independent of any statute. Then you go up and sit the different constitutional question when you ask, well, wait a minute, is it permissible for Congress to enlarge the power of a branch by passing a statute? So they said, no, you can't give the president the power to line item veto statutes. That is, veto individual items of appropriation instead of the entire statute. You've got to veto the whole statute or not, because that's required by the presentment clause and the bicameralism clause of the Constitution, which requires that legislation be passed by both houses of Congress and signed by the president. Similarly, Congress cannot have a legislative veto. The Supreme Court decided back in 1982 in the Chadha case, where they said, look, a one-house legislative veto of a decision by the Attorney General is Congress acting substantively. They're affecting the rights of people outside the legislative branch, and they can't do that unless, except through bicameralism, passage by both the House and Senate, and presentment to the president for signature or veto. Similarly, the judiciary can only act substantively through a case or controversy, through a litigated case or controversy, okay? And this is the reason that because they can only act through a litigated case or controversy and cannot give advisory opinions and cannot issue prospective binding substantive rules, that's the reason that all the constitutional issues about the FOMC have never been successfully litigated. Because you would say, well, Professor Pterson, there are 3 ways to challenge the FOMC and it's been around for 70 years. How can that be? I mean, these either have got to be decided or moot, right? The answer is, every single time someone has brought a challenge, the federal courts have found that the issue was non-justiciable, meaning that it wasn't a litigable case or controversy, because either someone didn't have an injury because of the composition of the FOMC, or their injury wasn't caused by the composition of the FOMC, or in the ultimate, we don't want to decide it, so please take it away from us doctrine of the DC Circuit Court of Appeals. The court says, you know, in our equitable discretion, we have discretion when we decide issues of equity. We're like injunctions. You're asking us for an injunction to enjoin the actions of the FOMC because they're private members. And we don't want to exercise our discretion that way. This is a too complicated issue. It involves too many sensitive issues, and so we're just going to dismiss the case. So not one single successful case, even though there have been at least 10 different challenges, some by members of Congress. What they say to members of Congress is, hey, you're members of Congress. Go back to your buddies and change the statute if you don't like it, right? The power's with Congress. And then when individuals challenge it, they say, well, wait a minute. How can you show you're really the ones who's hurt by those 5 members being on the board, okay? Now, finally, statutory restrictions. Well, we're going to get to this when we talk about the removal power, because the question is, how much can Congress remove the president's inherent power or restrict the president's inherent power by passing a statute? The big difference between the Bush administration and earlier administrations on the constitutional power of the presidency wasn't the size of this box, wasn't the size of the inherent power of the president without a statute. It was this issue. It was that the George W. Bush administration, even more than his father's, even more than Ronald Reagan's, even more than any prior president, said Congress simply can't restrict the president's power in all sorts of areas, okay? And so that's a huge ongoing constitutional issue. Issues with respect to the judiciary about could Congress strip jurisdiction from the federal judiciary and take away their ability to adjudicate specific types of cases never actually come to a real decision, but it's one of those big lurking constitutional issues. You notice the box here? You know what's in this box? Congress's attempts to restrict its own power? Nothing. They've never done it, ever, okay? Now, the reason this is important is because with these types of issues where you have the aggrandizement of the branch, the Supreme Court tends to be very, very formalist and say, you know, bicameralism presentment clauses says for when Congress legislates, it has to act through passage by the House and the Senate with presentment to the president for its signature or veto. We can read that clause formally. It creates a rule. Can't be changed. Doesn't matter that the shift of power has been to the executive branch and Congress is trying to recapture some of that authority it's delegated. Doesn't matter. It's a formal rule. It aggrandizes Congress too much to let them exercise substantive power other than through bicameralism and presentment. And this is going to be significant when we look at the independent agencies, in particular the decisions upholding the power of the independent agencies. Okay? Here, the court tends to be much more functionalist, weighing the impact on the ability of the branch to perform its job against the need for Congress to pass a particular statute. And that's where the removal issue comes up, okay? So that's sort of a basic description. Any questions about sort of the foundation of all this? By the way, you're welcome to have questions at any point.
I guess to fill that, to fill the legislative box with statutory restrictions on authority to act, if they set their own term limits, would that go in that box?
Oh, well, that could, although term limits is a good example of what something that might. And term limits have been struck down, but struck down more because of the limitation on the power of the electorate to elect whom they want. That's a good example of something that might be analyzed that way. Yeah. The reason it was struck down, though, is it's not so much because of the power of legislatures to be elected as much as they want, but the power of us to elect whomever we want for that type of position. Okay. All right. So let's talk briefly about the three potential doctrines. First, the non-delegation doctrine. For years during the 19th century, Congress increasingly gave the executive branch the power to make decisions, including writing regulations, and changing tariffs and doing all sorts of things where they expanded the power of the executive branch by statute. And those were consistently upheld until the mid-1930s. And in the mid-1930s, there were three decisions, Panama Refining, Schechter Poultry, and Carter Coal, where for the first time, and indeed the last time, Congress struck down those delegations as unconstitutional assignments of legislative authority to the executive branch. The key for our purposes is that there were two basic reasons why they were struck down. One, Congress said the delegation was not sufficiently specific and gave too much discretion and authority to the executive branch. And second, and this is what's really important to us, is that these delegations were certainly, in the case of Schechter and Carter Coal, to essentially private entities under the National Industrial Recovery Act, one of the New Deal statutes passed by Franklin Roosevelt and the Democratic Congress. And for example, in Schechter Poultry, the NIRA authorized individual industry boards to set standards for the industry. And in Carter Coal, they authorized independent 8 independent boards of coal companies to set prices for coal. And then these were then approved by the president. But the Supreme Court says this is too much authority to private officials and strikes it down as a delegation of Congress's legislative power, both too much to the executive branch and, this I can use, yes, to someone outside federal government. Okay? And so we've got two problems, too much authority up here and too unaccountable authority out there. All right? In 1944, the Supreme Court decided a case called Yackas, which is in your list. And in Yackas, the Supreme Court upheld a delegation of wage price authority to regulate wages and prices that was very broad. And they said, as long as there is some intelligible standard that is given to an executive agency, then the delegation is going to be upheld. And the reason that the non-delegation doctrine eventually died out is because it's really based on, the doctrine was based on the idea that Congress was giving legislative power to the executive branch, and that's not permissible. The executive branch has to execute the laws. The problem is, it's almost impossible to tell where legislative power ends and executive power begins, because there's always discretion to execute a statute. And so the executive branch always has a lot of room as to how to interpret the statute. And if Congress says, well, announce how you're going to interpret the statute in a regulation, that's as much executive as it is legislative. And so it's hard to say that that's giving legislative power to the executive branch, because it's really just them defining the scope of the discretion they have under the statute. Now, admittedly, what the court has been willing to call an intelligible standard can be pretty broad, like regulating in the public interest and necessity, public interest, convenience, and necessity, which is the delegation of the Federal Communications Commission and others. But the non-delegation doctrine essentially dead as it applies to the federal government, but not necessarily dead as it applies to a private entity. And if there were a private entity that might resuscitate the non-delegation doctrine, it could be the FOMC, okay? Second, the Appointments Clause. The Appointments Clause of the Constitution is contained in Article 2, which is the part of the Constitution that deals with the executive branch. So the Appointments Clause says, the President shall have power by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers, consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But Congress may by law vest the appointment of such inferior officers being people who report to someone between them and the President, as they think proper, and the President alone, the courts of law, are the heads of department. So this could be just read as kind of precatory, as not having any real substance to it. But in 1976, in a case called Buckley versus Vallejo, the Supreme Court decided that in the context of a challenge to the Federal Election Commission, which was made up of 2 members appointed by the Senate, 2 members appointed by the House, 2 members appointed by the President, that structure was unconstitutional because the members of the Federal Election Commission exercised enforcement power and regulatory power, and that made them officers of the United States who had to be appointed in accordance with the Appointments Clause by the President and with the advice and consent of the Senate. And the reason was that they exercised significant authority pursuant to the laws of the United States. Anyone exercising significant authority pursuant to the laws of the United States is an officer of the United States and therefore must be appointed in accordance with the Appointments Clause. The question with the FOMC is, are they officers of the United States? Do they exercise significant authority pursuant to the laws of the United States? Well, I'll leave that to Professor Wilmarth's discussion, but you surely know enough from Chairman Bernanke's discussion to know that the answer to that pretty clearly has to be yes. They're the most powerful agency in the entire government with respect to the monetary policy of the United States. My God, they may be the most powerful agency in the entire federal government. Our elections determined. They're determined by the economy. We hold the President accountable for the economy. Who has more power over the economy, the President or the FOMC? What do you think? I mean, take it away when you've got the chance, but reach your own judgments about that. It's hard to believe that they're not exercising significant authority pursuant to the law. Who
are the financial journalists paying attention to?
Yeah.
Who does the Wall Street Journal follow every day? Right.
Yeah, exactly. So the Appointments Clause issue is a huge issue here, and it's been questioned many times. Last, the President's removal power. You'll notice in the list I put in the removal clause of the Constitution, which there is none. It's blank. There is no removal clause in the Constitution. You might say, wait a minute, they talk about appointments, how come they don't talk about removals? That issue has been debated heatedly ever since 1789. When 1789, in one of the very first statutes, in the very first year of the very first Congress, Congress debated whether they should put a removal provision in a statute to appoint the Secretaries of War, Secretaries of State, and the Secretaries of Treasury. And the opposition was based on the ground that if we put a removal provision in, then it'll seem like the President can't remove them without our statutory authorization, and he already has the power to remove them. Well, this debate went back and forth, and it is still debated by historians now as to whether and what that debate signifies. The issue recurred throughout American history, first most notably in the impeachment of Andrew Johnson, who was impeached because the Tenure of Office Act, passed by Congress, said that you may not remove a cabinet secretary unless Congress concurs. And President Johnson thought that was unconstitutional, and he removed Secretary of War Stanton. The House impeached him for that. Senate came within one vote of convicting him for that. legitimacy of that statute was not resolved until 1926 in a case called Myers versus United States. And in Myers, Supreme Court considered the president's, a similar restriction on the president's removal power in the case of a much less significant official, the postmaster first class of the city of Portland, Oregon. And they decided the restriction on the president's right to remove that postmaster was unconstitutional. It was the same kind of statute as the tenure of office act. It required congressional removal. They could have treated it as this kind of statute, giving the legislature too much power to restrict removal and have a role in removal. But they did not. And this is really important because what they said was, no, it's this kind of issue. We're going to treat it as this kind of issue because the president, as the sole head of the executive branch, you notice that Congress has all legislative powers herein granted in Article 1, Section 1. The president has the executive power of the United States in Article 2, Section 1. Right? He has all the executive power. And the author of this opinion, the Chief Justice, said, the president has the right to supervise and control people within the executive branch, and in order to have that power, he has to have the power to remove them.
And guess who the chief executive was?
Yeah, who do you think the Chief Justice was at the time?
Anybody
know?
Right.
No, actually Brandeis disagreed with that opinion. He's a smarter guy than the Chief Justice was, but he didn't have the experience that the Chief Justice did with executive power.
Taft?
Yes, William Howard Taft. What he did was basically, his role on the scope of executive power was far greater as Chief Justice than it ever was during his one term as president, where he was more or less ineffectual. But as Chief Justice, he wrote an over 100-page opinion in Myers, setting forth basically what now is the core of the theory of the unitary executive. The president has the right under the vesting clause, Article 2, Section 1, and under the take care clause that the president shall take care that the laws are faithfully executed, to run the executive branch because he's responsible for everything that happens and he has to be accountable alone. And they cite back to the framers who expressly rejected a plural presidency, a plural executive branch, because there were proposals for other parts, a council or provision to exercise executive power jointly with the president. But they picked one president because they wanted one person to be accountable. And Chief Justice said that means he has to control the executive branch. To control the executive branch, he has to have the power to remove people. Therefore, a restriction on his power to remove is unconstitutional. So 9 years later, we get to 1935. We're in the midst of the New Deal and huge controversy over what President Roosevelt's doing. And the court gets a challenge in the case called Humphrey's Executive versus United States, in which the president has dismissed a member of the Federal Trade Commission who can only be dismissed under the statute for cause. And the issue is, well, is that constitutional? They're an independent agency. And what I want to do is I just want to read you from the decision, because it's the most interesting decision in a lot of ways of any separation of powers decision in the history of the court. Here's how the court began its analysis of policies underlying the issue of removal. The fundamental necessity of maintaining each of the three general departments of government entirely free from the control or coercive influence, direct or indirect, of either of the others, has often been stressed and is hardly open to serious question. So much is implied in the very fact of the separation of powers of these departments of the Constitution, and in the rule which recognizes their essential co-equality. The sound application of a principle that makes one master in his own house precludes him from imposing his control on the house of another who is master there. Who's going to win the case? Come on, after that, total formalism, right? So who's going to win? Who should be free from influence by someone else, some other branch?
The president.
The president, come on, right? You think, well, the president's won this case. Here's what they go on to say. The power of removal here claimed by the president falls within this principle, since its coercive influence threatens the independence of a commission, which is not only wholly disconnected from the executive department, but which, as already fully appears, was created by Congress as a means of carrying into operation legislative and judicial powers and as an agency of the legislative and judicial departments. What the hell is he talking about? That's unbelievable. It's like, it's the biggest fake out in the history of the Supreme Court, because they start with an incredibly formalist approach, and you're thinking, yeah, it's going to be for the president, and then they say, no, the formalist approach means that Congress wins, because this is like an agency of Congress. Well, there are 4 huge problems with this decision. Number one, we already know from the Chadha decision now that Congress, if they're going to act substantively, has to act through bicameralism and presentment. That's the procedure that they have to follow to affect the substantive rights of people, okay? Congress does not have the power to create a junior varsity Congress that will legislate on its behalf, okay? And that's what the court is talking about here. They're talking, there's a junior varsity Congress and a junior varsity court. By the way, a junior varsity court would also be unconstitutional if it's totally separate as an agency of the judicial branch, because it violates the requirements that judges serve during good behavior. Remember, independence, right? So a slightly different standard, even if they are independent and can be removed for cause. Federal judges cannot be removed by the president for cause. They can only be removed by impeachment, okay? It cannot be. That description is completely inconsistent with our current understanding of the limitations of the power of Congress, okay? Doesn't make sense. All right, second problem. The description of the agency as doing quasi-legislative and quasi-judicial power is rather incomplete. The Federal Trade Commission enforces the laws. They enforce the laws of the United States. They prosecute people. Yeah, they do some adjudication, and yes, they write regulations, but they also decide whom to prosecute. They have co-equal jurisdiction over the enforcement of the Sherman Antitrust Act with the Department of Justice. Exactly the same. One's assigned to the accountable Department of Justice. One part is assigned to now the technically unaccountable, independent FTC. How do they decide who gets what? They worked out an informal memorandum of understanding and just divided up every industry. So if you're Intel, hardware, computer hardware, you get investigated by the Federal Trade Commission, the independent agency. If you're Microsoft, computer software, you get investigated by the non-independent and accountable to the president, Department of Justice. Does that make any sense? No. It's completely ridiculous. They completely ignore the executive, purely executive prosecutive activity that the Federal Trade Commission exercises. Third, every federal agency does quasi-legislative and quasi-judicial stuff. The Department of Justice writes regulations. They adjudicate cases. The Attorney General has the right to finally adjudicate certain types of administrative law cases. And so there is nothing that distinguishes the FTC from any other federal agency, okay? Fourth, the underlying political science principle of the decision is announced by the court as follows. It flows straight from the progressive era of government. And those of you who are political science majors or have done history and know what the progressives believed in the late 19th and early 20th century, and it is clearly expressed here in this excerpt from the court's opinion. The commission is to be nonpartisan, and it must, from the very nature of its duties, act with entire impartiality. It is charged with the enforcement of no policy except the policy of law. Its duties are neither political nor executive, but predominantly quasi-judicial and quasi-legislative. Like the Interstate Commerce Commission, its members are called upon to exercise the trained judgment of a body of experts, appointed by law and informed by experience. Well, that is what the progressives thought in 1900. They thought that you could regulate scientifically and in a nonpartisan manner, and that by applying science to the regulation of a particular subject, you could, without any need for political judgment, decide what was right. We now know that that is precisely incorrect. It doesn't operate that way. The kind of policy on antitrust, for example, that a Bush Department of Justice will follow, or indeed a Bush-appointed Federal Trade Commission will follow, is entirely different from what an Obama FTC or an Obama Department of Justice will follow. Is vertical integration a good thing, or is it a bad thing that ought to be prohibited by the antitrust laws? Well, that's a matter of policy. You have to make some initial judgments about that before you decide whether it violates the antitrust laws or not. The every independent agency regulates differently because they're making certain policy judgments. Should the SEC, the Securities Exchange Commission, leave people working in the financial industry generally free from regulation, or regulate the heck out of them? Well, that's a political judgment. So the philosophical and political science foundation upon which the decision rested was, we would now say, completely false. But nevertheless, that was the reason that independent agencies survived. Robert Jackson, who was then the Attorney General of the United States, reported in his autobiography that Franklin Roosevelt, when he heard the decision and read the decision, said, "This is just the court taking the sharpest stick they can find and poking it right in my eye." Mm-hmm. That is all they meant to do in this case. Robert Jackson himself later became a distinguished member of the court, and he agreed with that. Not as a member of the court, but in private with the President Roosevelt. So for years and years and years, that was the, are we doing on time, okay? That was the basis for deciding whether an agency could be independent. If it exercised quasi-legislative and quasi-judicial power, even if it did a little enforcement as well, it could be independent, but anything that was purely executive, that had to be subject to presidential control, had to have no limitation on the president's right to fire someone. And then we had the challenge, the constitutional challenge of the Independent Counsel Act by Ted Olson when he was investigated back in the 1980s by an independent counsel for allegedly lying to Congress. And he mounted a challenge along with two other former Department of Justice employees, and said that the insulation of the independent counsel from removal except for cause was unconstitutional. And the argument, not surprisingly based on Humphrey's executor, was, okay, well, it's purely executive. They don't do any quasi-legislative, any quasi-judicial stuff, and you would think that he might win on that. Well, he lost the case badly with one dissent, Justice Scalia. And he lost because the court basically changed the test. And the test they came up with was something really much more suitable to this kind of issue, whether you can restrict the president's removal power. They said, well, you determine that constitutionally by weighing the impact on the president's ability to carry out his assigned constitutional functions against the need of Congress to insulate in that manner. And if the president's need outweighs, then it's unconstitutional. If it's the other way, then it's constitutional. The Independent Counsel Act is the strongest of all possible arguments for allowing independence. Why? Because the very problem Congress was trying to solve, the conflict of interest between a Department of Justice prosecutor charged with investigating a high-level executive official, is exactly the problem. And they can't solve that conflict of interest without creating some sort of barrier between the president and the investigator, right? It was the conflict, it was the very accountability that we usually want that caused the conflict of interest that the act was trying to avoid. And the limitation on the president's power was so narrow. It's one investigation at a time. So it's not very much of an intrusion on the full scope of presidential authority. But the need for it was, in Congress's mind, clear, because you can't eliminate the conflict of interest without affecting accountability. Okay? So the court upheld it. Now we have a new test. They don't show any sign that they're going to overturn the independence of other independent agencies, but under that test, it's hard to see why the FTC really needs to be independent compared to the Department of Justice. And the intrusion on the president's power is far, far greater. So the last case we get to is the challenge to the constitutionality of the PCAOB, the Public Company Accounting Oversight Board. Yeah. I knew I'd get it out. People in the business school call it peekaboo the same way that people in the law school do. No, yeah, you would take it more seriously than we do, I'm afraid. So the PCAOB was created as a subunit of the Securities and Exchange Commission and designed to regulate accounting companies and accounting procedures. And if you want to, you can describe much more and much better detail what they do. But they basically had substantial regulatory authority. They were appointed by the SEC, and so they were arguably inferior officers. But they're only removable for cause. So you had a double layer of removal for cause insulation. the SEC, as the Supreme Court determined, for cause, and the PCAOB removable for cause. And so the majority of the Supreme Court said that kind of double insulation is unconstitutional. You cannot have double insulation, and therefore the PCAOB must be removable at will by the SEC. Well, there are a couple interesting things about this decision. The first is that there is nothing in the statute creating the Securities Exchange Commission that says that they're only removable for cause. At the time the SEC was created, it was right before Humphrey's executor, and there was substantial uncertainty as to whether for-cause restrictions would be constitutional. And so Congress left it out. The reason the court says they're only removable for cause is because both parties agreed that they were removable for cause. Well, let's think about this. Well, who are the parties? The SEC, they want to say they're removable only for cause, right? It's in their interest. And then the people challenging the independence of the PCAOB, and they want to say that the Securities Exchange Commission is removable only for cause because that's the foundation of their constitutional argument. So they both have an interest in saying that what doesn't exist, in fact, exists. And the Supreme Court goes with that. And the dissent just reads them the Riot Act about that and says that's completely outrageous. You can't go by what the parties consent on this. You have to read the statute. And the Supreme Court doesn't. Here's why I think they did that. Because I think what they wanted to say was, well, we're not ready to strike down the independence of independent agencies. But you know what? We can at least strike down double independence, because that is too much of a restriction on the president's right to control the executive branch, too much of a restriction on the unitary executive. And therefore, at least what we can do is draw that line in the sand and say that you can't have an independent agency removable only for cause supervising another agency only removable for cause. Okay? Now, what do we have with the PCAO? What do we have with the FOMC? We have an agency removable only for cause, and it's clear that the Federal Reserve Board governors are removable only for cause. And we have the private members of the FOMC, the heads, the presidents of the regional banks, who, A, aren't removable from the FOMC at all, and they are removable as heads of the banks, but only for cause. It's a double for cause removal provision, and there is no way that that is constitutional under the PCAOB case. No way, okay? So here's what I'm going to leave you with, and to let Art talk about this and to have you think about it through the rest of the course. We've got three basic doctrines. Non-delegation doctrine, talking about the problem of delegating important public power by Congress to private entities. We've got a similar policy under the Appointments Clause, which says that officers of the United States have to be appointed by, especially principal officers, which I think these clearly are, have to be appointed by the president with the advice and consent of the Senate in order to make the president accountable for who he's picked, right? And we have the removal issue, which is designed to make people accountable because the president has to have some way to intervene and say you're not doing your job right, because someone has to be accountable. Now here's the sticking point, and this is what makes this whole thing so interesting. I think we can easily say that the FTC, the SEC, the FCC all make policy that we would want to be accountable, right? We want someone to be accountable for that, and there's the arguments for their independence are weak. The arguments for the FOMC, the board in charge of monetary policy, are rather more substantial. Do we really want to have the president calling up the FOMC in an election year and saying, boy, it'd be a really, really great thing if you just lowered interest rates to like -5.
President Nixon did that very successfully in 1972.
Yeah, well, my point exactly.
Right.
So
Arthur Burns said, okay.
So the question is, do we want them accountable? Because you know that's what the president would do, right? And would that be good for our long-term monetary policy? I'm not the economist, but even I know enough that that's bad economics, right? And so the argument for the independence of the FOMC is the strongest argument for anybody in the federal government outside the federal judiciary, right? It's a huge argument for independence. On the other hand, it's like, yeah, they are incredibly powerful. And so should they be accountable to no one? And especially should they come from just the private sector? And maybe they are accountable, not to the president, but to the banks or the money interests or whoever. And Art, you're going to tell us about the extent to which that may be true. Any questions, though, before I leave my rant on the stage? Okay, take it away, Art.
Okay, well, yes, Todd has set up my discussion very well, which is, okay, if we don't think that they're so accountable to the political branch, and I think that there's certainly a strong evidence that the Fed has substantial independence from the political branch, at least strictly speaking, whom might they be influenced by? And I think this unique governance structure, as I've been thinking about it more during the past year, I think it explains why, one reason why the influence of the financial services industry seems to be so strong, particularly the very largest institutions. Because the issue I've been pondering for the last few years is why were the regulators so unwilling or unable to stop the predatory lending and the subprime lending bubble that occurred? I mean, anyone looking at it from the outside objectively had to be very dubious, even from 2001, 2002 on. There were commissions and studies even as long ago as 1999 warning about the threats of subprime lending and predatory lending and what it might lead to. So there were plenty of people raising lots of warnings, including inside government. Why was nothing done, not only then, but even as late as 2006, when you see really no effective action being taken by any of the financial regulators to stop the bubble. So essentially nothing was effectively done until the bubble burst. Okay, to some extent, yes, the Fed began raising interest rates, particularly in 2006 and 2007, which may in fact have helped choke off the mortgage bubble and the housing rise. But on the regulatory front, nothing was done effectively. So I gave you part of this paper that's forthcoming as an article, and the part I gave you dealt mainly with regulatory failures. And I think with some of the agencies, it's fairly straightforward. I mean, the Office of the Control of the Currency, which regulates national banks, and the Office of Thrift Supervision, which then regulated federal thrifts, has now been put out of business. Now the OCC regulates federal thrifts as well. Those two agencies had very direct and stark conflicts of interest because their budgets were funded completely by the assessments paid by the institutions they regulated, and institutions could choose which regulator they wanted. And so if your budget's paid for by the people you regulate, you have a strong incentive to get more of them into your stable, and you particularly want to get the big ones into your stable. And it was very clear that the OCC was driven very largely by what the big national banks wanted. And the OTS, which was actually competing for a dwindling number of thrifts and was having some concerns about how viable they were going to be, was completely dominated by the large thrifts that remained, as I've pointed out. The Fed is harder to figure out because the Fed actually has an independent budget. Okay, they have an enormous portfolio of traditionally mainly of Treasury securities. Now, of course, due to the financial crisis, they have about a 3 times as big portfolio. Unfortunately, much of which consists of really some pretty dodgy stuff. A lot of mortgage-related assets and other things that are nothing like Treasuries in terms of their safety and soundness. But they make tremendous earnings off this portfolio. those earnings fund all of the Fed's operations. And they, in fact, return a surplus every year to the Treasury Department. I think last year they returned a surplus of about $200 billion to the Treasury Department in terms of earnings from their portfolio above the expenses of their operations. So the Fed doesn't have these budgetary concerns about, we have to keep the institutions happy or they won't stay with us. Plus, the Fed has control of all the bank holding companies, which are the holding companies for the major institutions. So that's not an explanation for why the Fed is so influenced. But this governance structure, begins to give us some insight as to the influence that might come to bear. So, 3 of the 9 directors of every Federal Reserve Bank are essentially bankers. And at least one of those bankers is going to be a very large banker. So it's not surprising to see Jamie Dimon, who's the chairman of J.P. Morgan Chase, the largest bank in the country, is on the board of the Federal Reserve Bank of New York. And similar big bank executives have been on the boards of other Federal Reserve regional banks. Class B directors are elected by the banks. They're not bankers, but they're obviously people who are supposed to have a knowledge of banking, and they clearly can have connections to banking. Not surprising to see people like Jeff, is it Immelt or Immelt, the chairman of GE? Immelt. So Jeff Immelt, chairman of GE, was Class B director on the New York Federal Reserve Bank during the last few years. I think he's still on it. Again, very closely connected to the banks. Many of these folks are customers, major customers of banks. The Class C directors are most interesting. The Class C directors are supposed to be public interest directors, and they are appointed by the Federal Reserve Board. But how do they get selected? Well, they get nominated by the Federal Reserve regional banks, and they're usually a slate of 2 for each seat, and then they get forwarded onto the Federal Reserve Board for approval and appointment. And again, if you look at the General Government Accountability Office report that I cited, it talks about, well, these folks are recruited by the Federal Reserve regional banks. They're recruited by people who are referred to them by their other directors, including the Class A and Class B directors. These are supposed to be people who are knowledgeable about the financial services industry. Interestingly, they can't be employed by the banks. They can't even own stock in the banks, right? But they're supposed to be knowledgeable. And the feeling is we should get people who are knowledgeable, and just anyone from the public might not be knowledgeable. And so you end up with Class C directors like Stephen Friedman, who was the former chairman of Goldman Sachs and a director of Goldman Sachs when he was appointed as Class C director on the New York Federal Reserve Regional Bank, and was made chairman of the board of the New York Regional Bank. And so, when you look at the report, it says, for example, that 80% of the directors of Federal Reserve regional banks between 2006 and 2010 were CEOs or presidents of either large financial organizations or large non-financial organizations. About 60% of them were people who had very extensive financial experience, even though the actual Federal Reserve Act says that Class B and Class C directors should be drawn from areas like agriculture, commerce, trade. It does say industry, but then it also says consumers and labor. Consumers and labor are 2 of the 7 groups that Class B and Class C directors are supposed to be drawn from. And the response was, well, during 2006 to 2010, only 10% of the directors of all the banks, only I think there were 12, and even if you take away the Class A directors, so that would be 12 out of 72 non-Class A directors were either representative of labor or representative of consumers on any of these banks. And then they asked, why so few? Why so few labor folks or consumer folks when those are 2 categories you're supposed to draw from? And the response was, they're too political. they're too politically active. And if you're a director of the Federal Reserve Bank, you're not supposed to be politically active. And I think, well, how politically active are people like Jamie Dimon and Jeff Immelt? I mean, Jeff Immelt's the chairman of the President's Council on Competition. I mean, Jamie Dimon, he's quoted every third day on some regulatory aspect dealing with Dodd-Frank. I mean, these folks are not politically active. I mean, you get this sense of a very club-like atmosphere, and the club needs to be aware of how the financial services industry works and what the financial services industry needs to succeed. Now, the strongest sort of arguments in this way have been made by Simon Johnson and James Kwok, who wrote this very well-known book called 13 Bankers. And basically what they describe is sort of a mindset, a mindset where what was good for big finance was good for the economy and good for the government. And I'll suggest that I think that their arguments have some plausibility. So of course, this creates problems because during the crisis, 18 Federal Reserve Bank directors were affiliated with institutions that either received TARP capital stock assistance or received emergency liquidity assistance from the Federal Reserve. And the Government Accountability Report says this certainly raises a serious concern about an apparent conflict of interest. Jamie Dimon, okay, now he claims they didn't need it, but they got $25 billion of TARP capital assistance. They got additional assistance in order to acquire Bear Stearns. They got some liquidity assistance. GE, which is not even a bank, was given $20 billion worth of commercial paper assistance. Reportedly, according to Secretary Paulson, in his book On the Brink, Mr. Immelt called him up in the middle of the night and said, "We can't roll over our commercial paper. You have to help us." Mr. Immelt says he can't recall that conversation now, but that's what's in the book. Well, they got $20 billion worth of commercial paper assistance. Even more extraordinary, they got $50 billion. They were allowed to issue $50 billion of FDIC guaranteed debt at a very low interest rate. Okay, the FDIC set up a special debt facility under the so-called systemic risk exception to the Federal Deposit Insurance Act. Can only be triggered with the most extraordinary measures, including concurrence by the Fed, concurrence by the Treasury, consultation with the President. The idea was a lot of banks couldn't issue debt. No one wanted to buy it. The banks needed to raise money. So the idea was, okay, the FDIC will stand behind this debt. The banks will issue it. The FDIC will stand behind it, and that will allow the banks to get to the debt markets. Okay, the banks issued about, in round numbers, about $300 billion worth of that debt. The lion's share of it was issued by the biggest banks. Interestingly, GE issued $50 billion worth of it, even if it wasn't a bank. It didn't qualify for the program, but they put it in the program anyway. Well, one begins to wonder, what is the appearance here? What is the reality? Then of course, there's been some studies, and the studies tend to show that, if banks had directors on the Federal Reserve regional bank boards or on their branches, first of all, those banks were much more likely to get TARP capital assistance than banks who didn't have people on the boards. And oh, by the way, those who had members on the boards were much more likely to survive than those who didn't have members on the boards. Now, are these just sort of false, spurious correlations? Maybe, but these were significant correlations done through regression studies. I mean, they weren't just sort of casual observations. Another study showed that banks that had their executives elected to the Federal Reserve regional boards immediately had a significant upward move in their stock market price. That, in other words, investors viewed that as a significant plus for the bank to have one of your executives on a Federal Reserve regional bank board. Now, of course, that's the investor's judgment. Is that foolish? Is it uninformed? Well, apparently they were willing to vote with their dollars and saying, I'll put more money in that bank because, like JP Morgan Chase, they've got Jamie Dimon on the bank board. So I think that the Fed's structure, right, has created this concern. Is this structure, put the Fed in a situation where they become, by the banks, of the banks, for the banks? Certainly there was some feeling like along those lines among Congress during the Dodd-Frank Act, because one thing they did was that they said, well, we won't let the Class A directors vote any longer for the president of each Federal Reserve Bank. So only the B and C directors can vote, which I think is a start. But of course, the banks still elect the Class B directors. The banks are still kind of indirectly involved in recruiting the Class C directors. So there's still, plenty of room for influence. I was speaking with Todd, and he was talking with a senior staffer on the Dodd-Frank drafting, and it was clear that some of the senators wanted to go much further, obviously.
A lot of them that were hoping to wipe out the private involvement on the board entirely.
Right, that there would be no more bank elections of directors, essentially. So that would have been much more radical to say that, in a sense, all of the directors would have been appointed under some kind of public interest, I suspect, analysis. I think Stephen Friedman, to me, is, his experience is indicative, I think, of what was considered acceptable at the time. Okay, so Stephen Friedman, former chairman of Goldman Sachs, current director of Goldman Sachs at the time, is appointed to the Federal Reserve Bank of New York board, I believe in 2008, and is made chairman of that board. Well, in the middle of 2008, when the crisis really got bad, Chairman Bernanke explained to you, they converted both under an emergency procedure, they converted Goldman Sachs and Morgan Stanley to the status of bank holding company. They had just been securities companies up until then. They were not regulated by the Fed in any direct way up until then, but the feeling was Morgan Stanley was particularly threatened, came very close to failure. Goldman Sachs was not close to failure, but was certainly considered vulnerable. And the feeling was, even though they were getting help from the Fed through liquidity assistance, through the so-called primary dealer credit facility, they needed to be brought inside the Fed stable as bank holding companies, where they would have assured access to the discount window and other Fed support. And the Fed would be sort of, in a sense, wrapping its imprimatur around these companies and saying, we want, they're part of us now. And so they were brought in under very emergency procedures in the late September 2008. Well, that presented a problem for Mr. Friedman. Okay, now he was a director and a significant stockholder of a bank holding company, which was not permitted for Class C directors. Now, he could have done one of two things. He could have resigned. He could have divested himself of all the Goldman stock, and I think he probably would have needed to step down from the Goldman board at all. He didn't do either. What he did was apply for a waiver. Now the question is, why would the Fed have been willing to consider a waiver? Well, one argument was he was so knowledgeable, so experienced. This was a difficult crisis period. You didn't want to change horses in the middle of the stream, as we've heard that. That was actually said by Franklin Roosevelt, right, in 1940 when he ran for his third term. You don't change horses in the middle of the stream. Well, they decided they didn't want to change horses, so they gave him a waiver. All right, the waiver was pending. He owned 46,000 shares of Goldman stock to begin with. He bought 37,000 more shares of Goldman while he's waiting for his waiver. Now, why would you do that? Well, during that period, Goldman gets extensive experience, more assistance, liquidity assistance. During that period, AIG is rescued by the New York Fed and the Federal Reserve Board, and AIG pays out 100 cents in the dollar all their credit default swaps to their counterparty banks, including $14 billion to Goldman. Would that be in any way useful for Mr. Friedman to know? I suspect it would be. He said later, well, I was just buying stock to show my confidence in Goldman. Well, I guess that was a patriotic thing to do. But a lot of people thought that that was not seemly. Then, in the midst of this, Mr. Geithner, who had been president of the Federal Reserve Bank of New York, accepted appointment as Secretary of the Treasury, they had to find a new president. It would seem odd, but they, maybe because Mr. Friedman was still chairman, they said, why don't you be chair of the search committee? Now, if I were Mr. Friedman, I'm not sure I would have done that, but he said, fine, I'll be chair of the search committee. Even though my waiver is still pending, the waiver finally came in, and the search committee came back, and guess they said, well, gee, there's this wonderful person named William Dudley. He should be the new president. Who's Mr. Dudley? Well, he used to be chief economist of Goldman Sachs. Now, he's a very able man, but you can begin to see the appearances piling upon appearances. And what's interesting to me is not that any of this was sort of horrible, but that no one particularly thought this would be objectionable. Of course, once this all came to light, there was a tremendous outcry because people said, wait a minute, how can this be? Why all these special waivers? Why all of these special treatments? And it looks like Goldman took care of Goldman. Now, maybe that wasn't at all the case, but it was interesting that wasn't considered problematic. Yes?
Touched on the fact that maybe it's just the fact that a lot of smart people work at Goldman. But what's this potential solution to stop that, potential, conflict of interest? Especially, I mean, the buying of 37,000 shares sounds very sketchy, but just appointing a chief economist from Goldman, well, maybe he was the best guy. So
right.
How do you solve that?
No, I think I think the appointment of Mr. Dudley would have been far less controversial if Mr. Friedman had not been involved in the process. So granted, it would take a statutory amendment, but I think this idea that the member banks elect the directors and have an indirect role in electing the president of an institution that regulates them. Now, I've heard the people from the Fed say, well, but they really don't have a direct role in the supervision. But what happens is that the Federal Reserve Board sets supervisory policies, but those supervisory policies are implemented through the Federal Reserve regional banks. And certainly the presidents and the first vice presidents who are elected in this way have a direct role in the supervisory policies. And so it seems to me for the banks to have any role at all in influencing who might be president or how that person might be perceived by the board and then would regulate the institutions, I think creates an incestuous feedback loop, which is undesirable. So I think, as Todd and I have said, I think the banks would actually do themselves a favor if they said, take away our right to elect directors. We shouldn't be electing directors because we are the regulated constituents of the boards, which at least indirectly appoint people who then supervise us. So I think that would create a much broader, arm's length appearance. In a sense, I think that it's an agency design question, and I think you want to create a design that doesn't make observers believe that the agency is in some way either captured or influenced by the institutions it regulates. I mean, I think the OCC has a similar problem, which is, can you set up a situation where you don't depend upon your budget, for the people you regulate? I mean, that, one way out of that might be to say you create one regulator for banking institutions, and you don't allow institutions to migrate from regulator to regulator, because the one problem is if you think you can lose your constituents, you're tempted to do things to persuade them not to leave you. We'll talk a little bit about that next time in terms of it's not only competition within the United States, it's also competition between the United States and foreign countries, in terms of institutions threatening to jump if you don't do what they like. So have we reached the appointed time?
Pushing hour for right now, but Art will be continuing on Thursday as we continue questions of independence. And as a lawyer, I find this just wonderful to hear about all these ethical conundrums and things like that. We'll build on that throughout the class. So thank you both very much.